All right, so you're renting a place in California, right? Well, 2025 is here, and guess what? It's bringing some changes to those landlord-tenant laws.
Yeah, some pretty big updates that renters really need to know about.
Exactly. So today we're diving deep into all that new stuff. You've got the rundown on these latest regulations. And
we're going to break it all down in plain English so you know exactly what's changing and how it affects you as a tenant.
Landlord-tenant law. It can be confusing, right? We're here to make it easy to understand and point out the stuff that really matters.
And maybe even share some things you'll find pretty useful.
For sure, for sure. And the good news is that these changes are aimed at making things, clearer and fairer for renters.
Definitely. And if you're in Orange County, Riverside, San Diego, or Los Angeles,
and you're facing eviction or just have questions about your rights as a tenant,
MartinezLawCenter.com is a great resource for information.
They specialize in helping tenants navigate those sometimes tricky situations.
Absolutely so.
Let's jump right in. We got a lot to cover. Changes to credit reporting application fees.
Right.
Charges your landlord can't hit you with any more protections for domestic violence victims. Updates to security deposits, how parking agreements are now separate.
Oh, yeah.
Longer timelines if you're facing eviction, and the latest on those balcony inspections.
Yep, all that good stuff.
Okay, so first up, something that could actually be pretty helpful for renters.
Okay.
How positive rent payments could affect your credit score.
You know what's interesting? This new law, AB 2747,
right?
It actually requires certain landlords to offer you the option of reporting your on-time rent payments to credit bureaus.
Okay, now this isn't for every landlord, though, is it?
No, it's generally for larger landlords, so those who own buildings with 15 or more units.
Got it.
Or if they own more than one rental property, and that includes things like REITs and corporations.
Okay.
Smaller landlords, the ones with 15 or fewer units and aren't part of a corporation,
right,
they're usually exempt.
So if I'm living in a bigger apartment complex, this is something I should be aware of.
Yeah, definitely something to watch for.
So when does this actually kick in?
Well, for any new lease starting on or after April 1st, 2025,
okay,
landlords have to offer this option.
Yeah.
And if you're already in a lease that started before that,
right,
they still need to let you know about this option at least once a year.
Oh, good. So they can't just leave existing tenants hanging.
Exactly. Everyone gets a chance.
Okay, now what about the cost of this? Is this going to be like another fee on top of my rent?
Well, they can charge a fee, but it's capped at either $10 a month or their actual costs to provide the reporting, whichever is lower.
Okay.
And if it doesn't cost them anything, they can't charge you at all.
That makes sense. That seems fair.
Yeah.
Now, what if I signed up for this, I'm building good credit, and then suddenly 1 month I just can't afford that extra reporting fee?
Right.
Could that lead to bigger problems?
That's a really good question. And the law actually addresses that landlords can't penalize you or try to evict you just because you didn't pay that reporting fee.
Okay.
However, they can stop reporting those positive payments.
Right.
If the fee goes unpaid for 30 days or more.
So it's really separate from my actual rent obligation.
Exactly. It's its own thing.
That's good to know. I mean, this whole thing sounds like a pretty cool opportunity for renters, like a new way to build credit.
Right. It's moving beyond just using credit cards or loans to improve your score.
Exactly. So you're actually getting credit for paying your rent on time.
Exactly, which is something you're doing anyway.
Yeah. I mean, it's worth looking into, especially for people who are just starting out or need to boost their credit.
Totally. And remember, it's mainly for those bigger landlords with the larger properties.
Right. Right. Okay. So that's credit reporting. Now let's talk about another big one, application fees.
Oh, yeah.
Seems like AB 2493 has really changed the game here.
It has. It's made things much clearer for both landlords and tenants.
Okay.
Landlords now have to choose between two ways of handling application fees.
Okay.
The sequential application process, or what's often called the MESA method.
MESA method, all right.
And the refundable screening fee process, which some people call the job interview method.
Interesting names. Let's start with the MESA method. So what's the main idea behind that one?
Well, it's all about being fair and transparent.
Okay.
The landlord has to process applications in the order they receive them.
Got it.
And they have to give you clear written criteria up front.
Okay.
So you know exactly what they're looking for in a tenant.
So no more guessing games or moving the goalposts.
Exactly. And the first applicant who meets all those criteria gets the rental.
So it's all about being first and qualified.
Exactly.
Okay, now what happens to everyone else's application fees? The people who applied but maybe weren't first or didn't quite meet the criteria?
Well, this is where it gets really interesting.
Okay.
If you weren't the first qualified applicant, the landlord has to refund your fee within 7 days.
Oh, wow.
Or they can offer to apply it to another property they have available.
Okay.
And it's your choice whether you want to do that or not.
So I'm not just losing that money.
Right. You have options.
Okay, what about those who didn't meet the criteria at all? Do they get their money back too?
The landlord can keep the fees from applicants who were considered and denied because they didn't meet those initial criteria that were clearly laid out.
Okay, so if they were upfront about what they're looking for,
Uh-huh.
and you just didn't meet those requirements,
Then they can keep the fee.
okay, that seems reasonable.
Yeah.
Now, how's this job interview method different?
With this one, the landlord basically has to refund the application fees to anyone they don't choose for the tenancy.
Okay,
Doesn't matter why you weren't selected. If you didn't get the place, your fee comes back.
interesting. So with that method, unless I'm the one signing the lease, I get my money back.
Exactly.
That's a pretty big difference.
It is, and that refund has to happen within 7 days of the landlord choosing a tenant,
Okay.
or within 30 days after you submitted your application, whichever comes first.
All right, so are there any rules about when landlords can even charge these fees in the first place, regardless of the method?
Absolutely. Under both methods, landlords can only charge an application fee if the rental unit is currently available,
Okay.
or if they have a reasonable expectation that it'll be available soon.
Got it.
They can't just collect fees willy-nilly.
That's good to know. That prevents them from just taking advantage.
Right. It protects you.
Now, if I do pay a screening fee, can I see what they found out about me?
Oh, for sure. If you pay that fee, you have the right to a copy of your credit report, no matter which method they're using.
Good to know. So the main takeaway for renters is to ask the landlord upfront which process they're using.
Absolutely.
They should be clear about their criteria than their refund policy.
Exactly. Transparency is key.
And if they're using the job interview method, remember, you should get that fee back if you're not chosen.
Exactly.
All right, now let's talk about some fees that landlords can't charge you anymore thanks to SB 611.
This is a win for tenants.
For sure.
SB 611 says landlords cannot charge you a fee for serving you with those legally required notices.
Okay.
Things like a 3-day notice to pay rent or quit.
Right.
Or a 60-day notice to end your tenancy.
I mean, dealing with those notices is stressful enough.
Right.
Without having to pay for the piece of paper.
Totally. They can't pass on that cost to you anymore.
Good. What other common charges are off the table now?
Well, another big one is they can't charge you a fee for paying rent with a physical check.
Oh, really?
Yep. So if you prefer that old school method,
Yeah.
you're good to go. No extra fees.
Well, that's a relief for a lot of people, I think.
Definitely simplifies things.
Makes sense. So these new laws, they're really about reducing some of those hidden costs for renters.
Exactly. Making it more transparent and fair.
Okay, let's move on to a topic that's really about safety lock changes for victims of domestic violence.
Yeah, this is covered under SB 1051, and it's a big deal.
It's such an important issue.
It is, and this law provides really crucial safety measures for tenants in vulnerable situations.
Absolutely. So walk us through this.
Okay, so if you or an immediate family member
Okay.
or someone living in your household is a victim of domestic violence,
Right.
and you can provide your landlord with proof of that.
Okay.
The landlord is legally required to pay for changing the locks on your rental unit.
And they have to do it pretty quickly, right?
Yeah, they have just 24 hours to comply.
Wow, that's fast.
It is because ensuring safety is paramount.
What if the landlord doesn't change those locks in time?
Well, if that happens, the law says you can actually change them yourself.
Okay.
You just have to notify the landlord within 24 hours that you've done it.
Right.
And provide them with a new key.
Got it. And are they still on the hook for the cost?
Yes. The landlord then has 21 days to reimburse you for what you spent on changing those locks.
Okay. That's good to know so the burden doesn't fall on the victim.
Exactly. It's about protecting them both physically and financially.
Right. It's really a powerful statement about prioritizing tenant safety.
It is. It recognizes the urgency of these situations.
Now, are there any protections against landlords who might try to retaliate against tenants who use this law?
Absolutely. They cannot deny your rental application or conditionally approve it just because you exercised your rights under this law.
Good. So seeking safety won't jeopardize your housing.
That's the goal, to provide that security.
All right, let's move on to something that affects pretty much every renter security deposits.
Oh, yeah. AB 2801 has made some big changes there.
It has, and it's all about more transparency, right?
Exactly. More accountability, too.
Okay, so what's new?
Well, now landlords have to take photos of the rental unit immediately after you move out.
Okay.
But here's the key. It has to be before any cleaning or repairs start.
So it's a snapshot of the condition as is.
Exactly.
Got it.
And then they have to take more photos after any repairs or cleaning are done.
Okay, so we have a before and after.
Exactly. A visual record.
And what do we do with these photos?
Well, they have to send them to you along with an itemized list of any deductions they're making from your security deposit.
Okay.
And they have to explain the costs for those deductions in writing.
Okay, all of that has to be sent when they return whatever's left of your deposit.
Right. It's all about clarity and documentation.
That seems really helpful, especially if there's a dispute about what's considered damage versus normal wear and tear.
Exactly. It takes away the guesswork.
Now, what about cleaning fees? Any changes there?
Yeah, they can't just automatically charge you for professional cleaning anymore.
Okay.
They can only charge for professional carpet cleaning or other professional cleaning if it's absolutely necessary to get the unit back to the condition it was in when you moved in.
Okay.
And normal wear and tear is excluded.
So they can't just hit me with a cleaning fee no matter what.
Right. It has to be justified.
This could save renters a lot of money.
Definitely.
So basically, I should expect more documentation about my security deposit.
Yes.
Including those before and after photos.
Uh-huh.
And know that they can't just charge me for routine cleaning.
Exactly.
Okay, good to know. Now let's switch gears and talk about parking agreements.
Okay.
AB 2898 has made some changes there too.
This is all about what they call unbundled parking.
Unbundled parking.
Basically, if your landlord charges for parking or has any kind of parking agreement,
Right.
that agreement now has to be in a separate document, totally separate from your residential lease.
So why the separation? What's the point of that?
It's all about protecting your housing.
Okay.
They don't want a situation where a tenant could be evicted because of something related to parking.
Right.
Like not paying a parking fee or violating the parking rules.
Okay, so by making it a separate agreement,
Uh-huh.
they can't use those parking issues as a reason to evict you from your home.
Exactly. Your housing is more secure.
That makes a lot of sense. It separates those two issues.
It does.
Okay, now let's talk about the eviction process itself.
Okay.
Looks like AB 2347 has changed the timeline for eviction lawsuits.
Yeah, so if your landlord files an eviction lawsuit against you,
Right.
that's legally called an unlawful detainer,
Okay.
you now have more time to respond.
Oh, that's good.
It used to be 5 business days.
Right. Now you have 10 business days to file your response.
That extra time could be really crucial for tenants.
Absolutely. It gives them more time to get legal advice, understand their options, and prepare a proper defense.
It's a big difference.
It can be a game changer.
And now, while this gives tenants more time at the beginning,
Right.
it actually speeds things up for landlords in some ways.
It does.
The time they have to file certain legal responses, things
Right.
like demurs or motions to strike,
Right.
has been reduced.
So it's kind of a balancing act.
It is. It streamlines the process in certain areas.
Okay, finally, let's touch on the updated deadline for those mandatory balcony inspections.
Yeah, this is from AB 2579.
So what's the latest?
Well, the original deadline was January 2025.
Right.
But they've pushed it back a whole year.
Okay.
So now it's January 1st, 2026.
So landlords have a little more time.
They do.
And who can actually do these inspections?
Well, licensed civil engineers are now explicitly authorized. In addition to the other qualified professionals who could already do it.
So that essentially expands the pool of inspectors.
Right. It makes it easier to get those inspections done.
And even though this is primarily for landlords, it's good for tenants to know that these inspections are happening.
Absolutely.
It's about safety and making sure those balconies are structurally sound.
Exactly.
Well, we've covered a lot today.
We have.
A deep dive into the new landlord tenant laws for 2025.
Lots of changes.
And it seems like these changes are really aimed at making things more transparent.
Definitely.
Fairer and providing better protections for renters in California.
Absolutely. That's the overarching goal.
We talked about positive rent reporting.
Right.
Changes to application fees, prohibited charges. More safety for victims of domestic violence, stricter rules for security deposits, separate parking agreements, extended timelines for eviction lawsuits, and the updated balcony inspection deadline.
We hit all the major points.
We did, and it's important for renters to understand these new laws.
Absolutely.
Knowing your rights and what landlords are obligated to do can make your whole renting experience smoother.
It empowers you.
And remember, if you're in Orange County, Riverside, San Diego, or Los Angeles, and you have questions about eviction unlawful detainer or your tenant rights,
MartinezLawCenter.com is a great place to go for information.
They're there to help.
Absolutely.
So as we wrap up this deep dive into the 2025 California Landlord Tenant Laws, I want you to think about this.
Okay.
How might you approach your next lease agreement or your interactions with your landlord differently now?
Good question.
With all these new rules in place,
Right.
what questions might you ask?
Yeah.
What things might you look for that you didn't consider before?
That's a great point.
These laws are there to protect you. So take the time to figure out how to use them to your advantage.
Absolutely. Knowledge is power.
It really is. All right. Thanks for joining us for this deep dive into the latest landlord tenant laws.
Thanks for having me.
And remember, stay informed, stay proactive, and know your rights.
Couldn't have said it better myself.
We'll see you next time on The Deep Dive.
Or later.
Call now 714-442-9741. Thank you.